Hello, my name is James Toner, and we're recording this video for our website. Today we're going to talk a little bit about arraignments. What is an arraignment? What is the attorney's role at an arraignment? And what we can do to prepare to ensure that our clients are released on low or no bail. An arraignment is the beginning of the criminal process. It's when a person is brought before a judge for the first time. If he's in custody, it's an in-custody arraignment. If he's out of custody, it's usually done on what we call a desk appearance ticket, or DAT. They show up with a ticket, they go before the judge, and the judge, you plead not guilty, and the case is put on for another day. But at an in-custody arraignment, two things are taking place. One, you're entering a plea of not guilty on the case for the first time in front of the judge. And number two, a bail bond hearing is conducted to determine whether the individual is a flight risk and can be, or not, and in that instance, could he be released in his own recognizance or with bail. Now, what does an attorney do to prepare for an arraignment? Three things. Number one, we want to get a lot of information from the client and family about pedigree and ties to the community. We want to have family members present in the courthouse. And number three, we want to have access to a bail bond agent. Now let's begin with number one. A judge's determination at that bail bond hearing is whether the individual is a risk of flight. Will he show up to court on the next court date? If he's from another jurisdiction, or if it's a very serious crime, the court takes into consideration these items to make a decision as to whether there should be some bail on the case. And the premise being, if there's money put aside for bail, if somebody puts their house on the line or a car on the line, they're less likely to miss their court appearances. Now, what does the attorney do to prepare for this? And oftentimes we get the call in the middle of the night. 4 o'clock in the morning there's an arrest, or 8 o'clock at night and there's an arraignment tomorrow morning at 9 o'clock in the morning. Or it's 10 in the morning and the person's being arraigned in 15 minutes and the family's sitting in the courthouse and they need a lawyer. So the first thing you want to do is you want to speak to the family and you want to get some very quick pedigree information. Do they know anything about the case? What are the charges? He had a fight with his wife last night, so then you sort of have the trigger. You understand that this is a domestic violence case. You know, the next question is, where is the spouse? Does she still want to prosecute? But where does he work? How many children does he have? Does he pay support? Has he ever been arrested before? Is he on parole? Is he on probation? Does he own a house? Does he work in the community? Does he own a business? You want to get all of that pedigree information so that you can make a sizable argument to the court that the individual ought to be released in his own recognizance, and that means released without bail. The next thing you do is you try to get contact with your client. Oftentimes he's kept in pens beneath the courthouse. You want to get access to those pens. A knowledgeable local lawyer will know how to get below the courthouse, what doors he needs to go through, what identifications he needs to show. And you want to get down there within a few minutes to discuss the case with the client. Get some facts on the case, find out, the serious nature of it or non-serious nature. Has he ever been arrested before? Has he ever been on parole or probation? Is he on parole or probation now? Has he ever violated parole? Has he ever violated probation? Has he ever failed to appear in court? Has he been brought back to court voluntarily or involuntarily, where they have to go out into the community and bring him back to court? You want to get all of these factors, because rest assured the prosecution will have that information available to them, and they will argue against you using this information to ask the judge to set bail on the case. So the attorney wants to be ready for that. You also want to find out a little bit about what happened the night before, what happened with the girlfriend. Does she still want to prosecute? Get as much information as you can on that case so that you're prepared for the judge. Now, the second thing we want to do to prepare for the arraignment is to make sure there are family members present in the courtroom. The worst thing that could happen is your client is being arraigned and there's no mother or father or children or spouse in the courtroom for them. The judge may not say it, but he sees it, and he looks at this person as yet another client who's committed a crime and has no one in the community that supports him. So bring the mother, bring the family, bring the girlfriend, have them standing in the courtroom when the arraignment is conducted. The last thing that we do, and the experienced criminal lawyer will do this, is have a bail bond agent standing by in the event that you anticipate that there'll be more bail on the case. Let's give you an example. You get the call, it's a DWI, there was an accident the night before, unfortunately there's a fatality, somebody died. Now, regardless of whether your client owns a business or a house in the community, has significant ties, has never been arrested before, the court is going to set bail on that case. It may not be $1 million in bail, but it could be $10,000, it could be $20,000, it could be $100,000 in bail. But you need to understand that that is very likely in this instance, and then have the bail bond agent standing by so that we can get a bond as quick as possible and get the individual released from jail. If there's time, I will often bring my clients over to the bail bond agent's office. We'll begin the paperwork, talk about collateral, talk about options, talk about the various bails that I will anticipate based on my knowledge of the judge, and get that paperwork done and ready. And when the arraignment's conducted, have the bail bond agent in the courtroom listening to the proceedings so that he can fill out the numbers on the bond directly after the arraignment. We can go back to his office, complete the paperwork, and get that paperwork in front of a judge. We want to get this information done early because it takes about 4 or 5 hours to process a bail bond. The information is processed, it has to be sworn to before a judge, and then it's hand-delivered over to the jail, whether it's in Riverhead or Nassau County or New York City. It has to be hand-delivered over to the sheriff's department. So if you wait to 3 o'clock, if you wait to 4 o'clock in the afternoon, it is simply not going to happen until the next day. So we want to act quickly. Again, 3 things. Get as much information that you can, get that family present in the courtroom, and have direct access to a bail bond agent. Well, I hope this has been informative to you. Again, my name is James Toner. I'm a criminal defense lawyer in Mineola. My website is www.tonerlawfirm.com. You can visit our site, or you can call us at 516-294-1133. Thank you for listening.